Hello friends, welcome back to another long play format video where we have an informal conversation about what's going on. Today we've got three interesting topics to go over. Number one is the gun ban that was upheld by a 13th Circuit Court Chief Judge for Virginia. Second thing we're going to talk about are bills that have passed the Senate floor. And the last thing we're going to talk about will be bills to keep an eye out for in the upcoming weeks. All right, you know how it goes. Before we get into it, don't forget to head on over to YouTube, like and subscribe. Follow me on Facebook and Twitter. Those things are great. And if you click that little support button right there, that helps me grab a cup of coffee in the middle of the night, lets me know you appreciate what I'm doing. And the proceeds go to doing things like this. We've got the Virginia Second Amendment News webpage up right now, and it's just a great place to document the struggles and the things that are happening in Virginia. It's another place where we can put the videos. So I want to thank everybody that's put some cash in that bucket right there, send me some coffee in the middle of the night in order to make sure that I can do things like put this up and travel across the state. Really important. But let's get right into it. Let's just jump right into it. This is from the Resurgent, January 16th, 2020. Richmond judge allows Northam's gun ban to proceed. Gun groups promised to sue, and they did. The VCDL, along with the GOA, did bring a suit, and they were denied. We're going to talk about that. That's what the bulk of today's conversation will be about, getting you the information and a quick read through the three-page decision that the judge issued. And who is this judge? Well, it's interesting. It's a Joy Taylor, and we're going to find out a little bit about her as well. This article by the Gun Owners of America, what's going on here is it just says, hey, the gun ban was announced. The GOA and the VCDL went ahead and filed suit immediately. Let's go back over here to the Richmond Times, or the Resurgent, I should say. Just a picture. And here is, hey, this was taken a couple years ago, this photo, but that's kind of his idea, right? That's kind of Ralph Northam. Hey, it's just cool. Hey, what's up? And the concept here is what we just heard. Joy Jeter Taylor of the Richmond Circuit Court denied the request for a temporary injunction on the gun ban in Capitol Square in the state capitol, meaning Governor Northam's emergency declaration will go into effect tomorrow at 5 p.m. We come down here to this guy, Cam Thompson. I really like this because Cam Thompson had the material that we want to look at, which is actually the decision, three-page decision. But before we get into that, let's just look. Who is Joy Jeter Taylor? Well, I found her over here on the Virginia Judicial Systems Courts. That was pretty simple. I even tried to Wikipedia. I was looking for a picture, and I couldn't find a very good one. Okay, so here we go. This we've got Richmond Free Press is the only place I could find a photo. And here's a photo of Judge Joy Jeter Taylor as she's being sworn into the Richmond Circuit Court. This was taken on March 19th, 2015. So this is the lady that made the ruling denying freedoms of the Second Amendment to us. Now, she's got some really interesting reasons why she denied it. And maybe she's right. I don't know, you guys. You guys let me know down in the comments below. Maybe she's right, right? I'm kidding. I don't think she's right. But when we read this real quick, there's a couple of things. I'm going to gloss over this so that it doesn't take too long. But it's prefacing this. On January 15th, 2020, the parties appeared before the Circuit Court on the plaintiff's complaint of the application for a temporary injunction of the intervening Executive Order 49, the executive order which cites the Virginia Code that gives the governor the authority to issue such an order. And the order of the authority is the reason for the authority is the authority and responsibility for the formulation and administration of the policies of the executive branch. And the Department of General Services, as a member of the executive branch, is vested with the control of the Capitol Square and other property at the seat of government pursuant to the Virginia Code. Okay, so this is right here is her statement. This whole first page, this whole first part of this first paragraph is just her explaining the code, the reason, and what happened. I came, they wanted to do this. The plaintiff, which was the VCDL and the GOA, came together. They wanted an injunction for something that a governing body was doing. And this is the reason the governing body was doing it, based on these codes. So she's just setting out that framework. Okay, so, she continues halfway through after citing the code about Capitol Square and who's in charge of it and the reason that it needs to be done and what administrative power is there. She goes on to say that the department is instructed to exercise that authority under the direction and control of the governor. She cites another Virginia code. Furthermore, the governor is vested with the power to take action from time to time as necessary for the adequate promotion and coordination of state and local emergency services activities relating to the safety and the welfare of the Commonwealth. And she goes on, where the governor declares a state of emergency, courts must give deference to the professional judgment of those tasked with making complex, subtle, and professional decisions. And then she cites some case law, Winter versus Natural Resource Defense Council. Okay, so basically, she's quoting there, and she's quoting law that's already established. So this is procedure it's precedent. It's already there. She's recognizing that the courts shouldn't try to interject their authority over the person making the decision that's elected to do it. This is bogus. That's exactly what they're supposed to do. But she's able to do that on case law. Obviously, as a judicial representative, as a protector of the Constitution, she should be able to decide if something that an official is doing is constitutional or not. She shouldn't just accept the idea or the precedent in Winter versus Natural Resource Defense Council that courts must give deference to professional judgment. No. That's why we have the courts. That's why she's there. She's not there to give deference. She's not there to pass the buck and allow the governor to make the decision without any thought on her own, which is what she's saying right here. She's there. Her purpose is to check the governor, but she doesn't. It goes on to say that courts must give deference to the professional judgment of the military authorities concerning the relative importance of particular military interests when evaluating a motion for a preliminary injunction. So she's now backing up the reason that she's going to give her deference because she knows someone like me or you that heard this mess would say, you're not supposed to do that. She's just citing a case. She's just saying that, hey, when it deals with the military, well, we should let the military commanders have a little bit extra leeway, so we should give them that room, give that deference. This is the entire way that her argument is going to be posed throughout this three-page decision. So I'm going to skip to a couple things and statements that she makes that are pretty important. In this end of this first paragraph on the second page, she's saying that the court finds that the governor is granted sufficient deference within and has sufficient authority outside the Commonwealth of Virginia Emergency Services and Land Disaster Law of 2000, by which he could enact Executive Order 49. So we go on in her explanation. In evaluating whether the plaintiffs would suffer irreparable harm in this case, the court is guided by the principles adjudicated in Heller versus District of Columbia, namely the Second Amendment right to keep and bear arms is not unlimited. Ooh. Okay, so we know what Heller versus DC. This is a big groundbreaking case. Many times people use Heller versus District of Columbia as a reason to keep and bear arms, but we generally have seen Heller versus DC as a win for citizens because that really restricted the courts to take away in localities, to take away a right to assemble with firearms and carry firearms because it established those kinds of things. For what she's saying is that some of the tests that Scalia put out in Heller versus DC, she's going to use in order to restrict the rights because Heller versus DC did show that the right to keep and bear arms was not universal in all cases, but those are so far of extreme kind of cases and tests that they wouldn't normally be twisted to affect you and I until now, right? Okay, so in evaluating this, Scalia found in Heller versus DC found that the Second Amendment right to keep and bear arms is not unlimited. Accordingly, the court noted in Heller that nothing, in their opinion, should be taken to cast doubt on the long-standing prohibitions on the possession of firearms by felons and the mentally ill, or laws forbidding the carrying of firearms in sensitive places such as schools and government buildings. The Circuit Court of the District of Columbia relied on the principle when it ruled that the capital ground ban of weapons does not impinge on the right protected by the Second Amendment. She goes on to say that the Capitol Square in Richmond, Virginia contains office buildings for many state employees, and these buildings are sensitive locations, and as they are sufficiently integrated within the Capitol. Additionally, case law demonstrates that because individuals have limited right to bear arms, the plaintiffs in this case will not suffer an irreparable harm sufficient to justify an injunction sought by the plaintiffs. Accordingly, and upon consideration of the evidence, argument of the parties, and the relevant law, the court hereby denies the application for a temporary injunction. Wow. So when she's talking about the foregoing case law, she's just talking about everything that she's said here. So there we have it. This real quick, top level down, just brass tacks look at it. It's really a 3-page document that explains I'm not gonna go against the governor, okay, because I don't have enough decision-making authority, and I shouldn't go against the governor because case law precedent says that I should give deference, which means leeway, give the decision-making to the governor, and I'm not a person in charge, although she is. She's the constitutional authority here, not the governor. And then she explains why she's doing it. She then states case law from Heller versus D.C., which is widely seen as a boon for Second Amendment enthusiasts because it did protect us, using some of the tests and statements in there, such as recognizing that mentally ill and felons shouldn't have firearms. She then says that, hey, you can't have them everywhere, like on different school grounds and stuff like that, so it's not a universal right. So you don't have any reason to have them here either. Wow. There she is. She said it. Makes you wonder, doesn't it? Let's move on to some other things. Looking through the legislative information system today, the LIS, and I found a lot of cool stuff. A lot of things to keep an eye on. We're going to look at about 6 different bills to keep your eyeballs on, and then we're going to look at 3 bills that actually passed. Who's having fun yet? Let me know down in the comments below. House Bill 61 or 161, carrying a concealed handgun permit not required. This sounds really great, doesn't it? And it's serious. Carrying a concealed handgun, permit not required. It allows any person who is otherwise eligible to obtain a resident concealed handgun permit to carry a concealed handgun without a permit anywhere he may lawfully carry a handgun openly within the Commonwealth. That sounds great. Even when we look at this, this was introduced on December 23rd, 2019. The law is quite a bit larger. It explains places where people can carry and can't carry. They're all the same places that you think. It explains when different types of people, when they're on duty, off duty, the harbor master, the Commonwealth attorney, judges, stuff like that. They have exemptions to these laws, things along those lines. And yeah, it's great. So here we have McGuire and Cole are the patrons, and they have submitted this bill. McGuire is a Republican, I believe. Let's find out. Yeah, he's a Republican in the House 56th District. This is great. Go ahead and send him an attaboy. But here you go. Carrying or storing of firearms in motor vehicles and vessels, exemptions and penalties. Yeah, this isn't so great. So basically, this one right here says that if you carry a firearm in your vehicle, it has to be in a container away from the dominion of anyone in the vehicle and locked, as well as separated from the ammunition. Now, this may not sound so much different than what you're used to, but you can't put it in a glove box. Okay? You can't have that anywhere that you could get to it. So, except if you've got a concealed handgun permit. Okay? So, if you get rid of the concealed handgun permit requirement and no one gets concealed handgun permits, then if they're carrying concealed and they're in a car and a police officer stops them, they're breaking the law, $2,500 civil penalty. Not criminal, civil. How do you like that? Do you see how twisted this stuff is? So it's like tit for tat here. I just find it funny. Let's move on. 961. We've already talked about that. We know that Senate Bill 16 was pulled by Dick Saslaw. Senate Bill 961 is here. It hasn't gone very far since the 7th, but it will. Lots of things in the House right now are kind of at a standstill. They're going to committees and being talked about. The Senate is pushing bills through much quicker right now, probably because they have fewer people, but they have just as many bills when I was looking through, so who knows. So 961, even though 16 is out, SB 16 is out, 961 is here, and it's got the assault firearms, certain firearm magazines, silencers, trigger activators, penalties. So all of those bills that died or were withdrawn have been incorporated into 961, at least the ones from the House. And the reason that the Senate bills were so inflammatory when they came out was because they came out right around November 18th. People were able to see them just after the election, and the Senate dropped a ton of them. Now the House is getting to work, and they're dropping all their bills. So some of the Senate bills are dropping off as the House bills are updated with new information or responses to our political pressure, and which there have been some. But anyways, let's move right along. Firearms control in local government buildings, waiver of sovereign immunity. This is a Campbell. Sounds like a Republican idea. Yeah, this is great. Okay, so the concept here is real simple, just like it sounds. House Bill 1382 says firearms control in local government buildings, waiver of sovereign immunity. This is by Jeffrey Campbell. Sounds like a Republican. Yeah, okay, so this means that if they ban guns in government buildings or city buildings, that the government, the state, or the city are liable for all that happens on there if anybody's hurt, and they have a duty to protect actively. See, law enforcement officers are sworn to protect the peace of the public, not your peace, not my peace, but the public peace, right? Not our peace, which means that they're not there to protect us. They're there to protect the infrastructure, the property, the public, whatever the public is. It's not the private citizen. So if they ban firearms in public buildings, then this bill right here, 1382, puts a requirement that the office actually places the security of the people and the protection of them paramount, holds them negligent if anything happens, and removes their waiver or removes their sovereignty and immunity if something does happen, which means dollar bills. Moving right along, carrying of loaded firearms. This one right here is pretty simple, and what it's going to talk about, once again, concealed weapons that we saw earlier. No requirement to carry concealed. Can't carry in your car if it's a locked container. But here we go. It shall be unlawful for any person to carry a loaded semi-automatic centerfire pistol or rifle that can hold more than 20 rounds of ammunition or is designed to accommodate a silencer or folding stock, or a shotgun with a magazine that can hold 7 rounds at the longest ammunition for which is chambered, on any public street, roadside, alleyway, public walk, anything, especially in the cities of Alexandria, Chesapeake, Fairfax Falls Church, Newport News, Richmond, Norfolk, Virginia Beach, or in the counties of Arlington, Fairfax, Henrico, Ludlam, and Prince William. Great. So what we're saying is you can't have a loaded firearm in there. Now, there's a couple ways that you could read it. I think the way that it's intended to be read is that anything that is, especially for the pistol or the rifle, it says specifically more than 20 rounds of ammunition. But they're going to ban magazines anyways, right, for 10 rounds. So there, again, this is another issue, and it talks about being loaded. So the way that I read it, it would read that you couldn't have a magazine with more than 20 rounds, but you could also read this a different way that says you can't have anything loaded in these areas. Now, this reminds me back when I first got my CWP back in, the early 2000s, late 1990s, early 2000s. It just reminds me of when you couldn't carry a loaded firearm. The magazine could be in, but the round couldn't be in the tube, so to speak. Okay, so let's look at bills that are actually moving. Senate Bill 35, firearms at permitted events. Well, guess what? This bill that authorizes any locality or by ordinance to prohibit the possession or carrying of firearms and the ammunition or any components at their local event has passed the Senate. 21 to 19. There are 21 Democrats in our House Senate. There are 19 Republicans. For some reason, I thought there was an independent in there somewhere, but maybe they're just grouping them together right now. Yeah, so this one passed down party lines. And so, as you can see, the Democrats can pass whatever they want down party lines. Okay, here we go again. This is Senate Bill 69, limitations on handgun purchases and penalties. This is terrible. We're back to the one handgun a month. This has already passed the Senate. It's got to pass the House and get signed by the governor. One handgun a month, except a couple of things if you've got a CWP. Well, here you go. We saw that bill earlier. Maybe they want that bill to get passed so that you don't apply for a concealed weapons permit. So it helps get rid of this loophole right there. Because if you got a CWP, this does not apply. But if you don't, then if you buy more than one a month, you're in a big deal of trouble. Okay? And of course, there are other exemptions. Once again, 21 to 19. You want to guess how many of those were Republicans? Well, we don't know because they won't tell us just yet. And this is frustrating because they should know. We should have that information. But the likelihood is it went down party lines. Democrats 21, Republicans 19. But here's the problem. Senate Bill 70, Senate Bill 70, firearms transfers, criminal history record check. This is the background, the universal background check and all that other stuff. It has passed. Okay? It has passed, no problem. 23 to 17. Some of our Republicans jumped ship. This is a problem. Now, I've already looked because I'd like to find out who the two Republicans are so that we could hit them up with emails and phone calls and just, oh man, this is terrible. What are they doing? Why? No, we're trying to get the Democrats to come over to our side, especially the more moderate-leaning Democrats, and say, hey, there are already checks. You've got your Virginia form, you got your state police form, there's a federal form, or two of those might be the same, but I know that I fill out 2 forms when I go there. Goes through a NICS check, everything else. I mean, they've already been checked, plus my CWP. I've been fingerprinted back in the day for my firearm. How many more checks do I need to go through? How many more checks do you need to go through? This is ridiculous. Why do rhinos? I'm going to find out your name, guys, and we need to contact them. This is a problem, and they're being protected right now in this video from this page. Man, it makes me mad. It burns me. Friends, that is all the news that is fit to print tonight. Well, maybe not exactly all the news, but it's just the news that I felt moved to share with you. I want to thank you guys for watching. I want you to remember that I will be with you on January 20th up in Richmond. There is a shoot going on in Virginia Beach sponsored by the VCDL and Freedom Shooting Center. Get there at 6 o'clock. It's Bring Your Own Ammo. Brendan Mooney is the host. Hook up with him over on Facebook if you'd like. And it's a little competition. It's just a lot of fun and fellowship. There could be some media there. I'm going to try to be there depending on my schedule tomorrow, just so I can get us out shooting, having a good time, being lawful and being careful, and having some fellowship and stuff like that. It'd be nice to see everybody again before Lobby Day. Let's get excited for Lobby Day. I guess the final note goes out to Lobby Day. That's the lady that did it. She upheld the gun ban by the governor. Guys, I'm Robert Ham with Virginia Second Amendment News. I'm fighting for your rights. Thank you for watching.